We had a quorum at the appointed time. The first item of the agenda, the proposal to amend the Immigration Ordinance. We invite the administration team into the room. We welcome Mr. Cyrus Cheung Ho-Ji, Assistant Secretary for Security Review 1, and Mr. Billy Wu, Principal Assistant Secretary for Security Review, and Mr. Isaac So, Principal Immigration Officer of the Immigration Department on Removal, Assessment, and Litigation. May we have P.S. Mr. Wu to walk us through the administration's paper. So you have a PowerPoint presentation today. Chairman and members, last week we provided a paper to the subcommittee. In previous meeting, members asked for a systematic presentation of numbers. For example, the number of appeal lodged after being rejected, as well as the number of removals after appeal denied. And we just want to give you a snapshot of the latest situation as of end of October. And this July, as we have consulted the security panel members on the proposed amendments to Immigration Ordinance, and this July, and we have submitted proposals to the Bar Association and the Hong Kong League Lawyer Society. We have received feedback, and some of the immigration organizations have provided some feedback, and of some of the areas, for example, the time frame to submit the claims, as well as the interpretation at the detention immigration center management. And thirdly, some of the legislative proposal is still being explored. And I would like to take this opportunity to brief you on the scope and to listen to the members' views. So if you agree, we shall begin the presentation now. And after the implementation of the USM on March 2014, as of end of October, within 4.5 years, we've received a total of 16,386, and together with the close to 42,000 cases before the USM, and those that 2001 torture claims to total cases pending screening breakdown was 23,085, and 30%, which is about 6,600 that before the immigration decision they have withdrawal and no further action could be taken. And for the 16,000 cases, and about the immigration decision have made a decision on the and only about 13 cases that are pending screening. And of this 15,011 cases have been about 77 substantiated by the Immigration Department, and the rest were rejected. And of those 15,034 rejections, about 14,000 of those have lodged an appeal, which made of 93% of the screened cases. And for the 14,000 appeals, the TCAB have completed 5,800 of those, and about 16,000 cases have the appeal withdrawn and no further action could be taken. And those pending about around 6,500 cases, which made up 47% of the total appeals. And taking total of the total 23,085 cases, this 6,000 or so appeal cases, and about 13,000 cases pending screening by immigration. The unscreened cases made up of about 1/3 of those, and the 2/3 of those have completed all procedures. And for example, they made the appeal rejected, and after they did not fail to lodge an appeal or withdrew the case in different phase. And members also concerned about the removal situation, and for those some of the cases may involve an individual reopening or filing subsequent claims. And for the 23,000 cases, the number of persons involved about 22,000 cases. We can break it down into 3 parts. About 8,000 of those, about 36% of those had removed from Hong Kong. And about 8,000 of those have their claims and appeal pending. I expect that this category can continue to shrink in numbers. And about 6,000 of those under USM, they have exhausted all their procedures and about to be removed ASAP. About 1,600 of those are being imprisoned or in the criminal procedures that have yet to left Hong Kong. About 2,800 of those have launched a judicial review. About 1,600 of those are arranging the removal. So that was the situation as of the end of October. And now I would like to walk you through the various options being considered. And there were some views that raised that to limit the time frame. If they didn't file an application within a certain time in Hong Kong, that it will propose that across the board rejection. That we agreed that the claimants have responsibility to lodge the claim ASAP. However, we need to carefully explore whether this across the board rejection would whether it would meet the high standard of fairness laid down by the courts with any compromise solutions. For example, for those applicants who filed past the deadline still able to file their claim. And some mentioned that the TCAB should publish their appeal decisions. So we are taking reference to other jurisdictions. And suppose that it would go ahead with the proposal, should we publish the decision in full or reject certain portions or provide a summary? And we will also look into the other jurisdictions' provisions. So we haven't got to a decision yet. And some of the claimants whose appeal has been denied have lodged JR, and we'd like to look into the government's obligation to this. Depends on the legal advice given. We need to look at whether to consider revising current arrangements or whether we should amend the legislations to make the removals more effective. And detention, the Immigration Department have following the common law principle, and for those pending removal, their detention time will be regarded as unreasonable. We consider amending the legislation while considering whether the time in custody was reasonable to consider other factors. For example, if the immigration is confronting a huge backlog, or if the claim is an cooperative, and the immigration can continue to hold the person in custody, and what constitute unreasonable detention. We also considered expanding the work of combating illegal employment, and for those do not restricted, for example, to tourists overstaying, to include them in the noble work, instead of using the lighter provision of violating condition of stay to institute prosecutions. We also need to consider to tighten the penalty to employers and laws have required some airlines to ensure they passengers are holding a valid travel documents. As suppose those that country need to require passport, they need to have the visa in their passport as well when are considering to toughen up the penalty if the airline have contravened the provisions where the penalty should be enhanced. We need to consider or looking into ways to strengthen the liaison with the airline companies for a effective deterrence of potential claimants coming to Hong Kong. And some of the legal sector things at the operation of USM, of combining the statutory mechanism and administrative procedures as unsatisfactory, will consider that new legislation will include the relevant legal ruling in the provisions so as to provide a full legal underpinning for the USM. And we haven't finalized the proposals yet, and upon completion we'll brief the security briefing on our final proposal. That our target that is to introduce the lecture in the upper half of 2019 for scrutiny. We have 4 members put up their hand: Fernando Chan, Gary Chan, Julius Ho, and Yu Si Wei. Since Dr. Chick's not here, let's start with Mr. Gary Chan. 5 minutes, Q&A included. From the figures provided by the SB, that substantiated 15,000 cases. Those that have been substantiated, there's about 77 of those, which made up of less than 0.5% overall, which indicated that our current mechanism is being abused. So I support the government to amend the Immigration Ordinance ASAP to enhance the efficiency of USM. However, if we have to go about the administrative amendment, it will take longer time, and the pressure at the community level or the security threats is already a common sight. As without you have this South Asian ghettos in Yang Ma Che, Mong Kok, not only they have very terrible hygiene conditions, and they're give rise to theft, criminal cases, and fighting. Will the Security Bureau take any enforcement actions against this kind of black spots? I also noticed that in the figures mentioned that about 1,600 individuals arranging removal. This 1,600 arranging removal, they have exhausted their appeal. How long does it take to remove them from Hong Kong?
Thirdly, going back to the numbers, we have 16,000 people who are now in custody. I understand that you have 160 people whose claims have been rejected, and 100,000 on the custody, and all 3,200 of them are now being, they are now in the custody of the CSD, and that is putting a lot of pressure on the CSD. So will the department require any special arrangements to take care of these claimants? And if so, does the CSD have enough manpower and resources to cope with the additional workload? P.S. Thank you, Mr. Chan, for your questions. Regarding law and order, we have been closely monitoring the situation. In particular, peop in areas where these claimants are live, and I think the police has already stepped up patrol in those black spots, and the police is also aware that some of these people might be involved in organized crime. So the organized crime division has set up a special task force to step up law enforcement to tackle the problem. Regarding the numbers, I think repatriation involves, several things. First of all, many of these claimants have already been in Hong Kong for some time. For them to be removed, we would need to liaise with the consulate office of their respective home countries to confirm the identity and to issue them with documents so that they could be removed. And we also need to arrange for the flights to take them home. And this is not something which the SAR government can do alone. We would need to work with the relevant, governments and consulate offices. So how long this would take would depend on, the arrangements we have with those respective countries, and whether or not, flights are available. Normally, within 1 to 6 months, it could be done. But there have been cases where which took longer. So we are already expediting the processing of the appeals, and with some of the major, countries where these claimants come from, are already discussing with them as to how we can expedite the process. As for the CSD, I understand that in the last few years, the total number of they have come up with appropriate manpower, arrangement, taking into consideration the number of people in custody. Have they been given additional manpower? Or if there is an increase in the number of people in custody, we will cater to that when they apply for resource allocation. Mr. Jonas Ho. I welcome the proposal to amend the legislation, and that this should be implemented in March next year. That is indeed good news, because this is certainly going to be an improvement, so that the so-called fake claimants can make use of the legal loopholes and abuse our procedures, and also wasting our resources. Now, looking at the numbers, I have heard previously that if people volunteer to be, removed, they would be offered some repatriation funds. I don't know whether you could further explore this option. We do not have many people remaining yet to be removed. If we could offer them a little bit more incentive, rather than procrastinating, they would be wasting the time, because they would not be successful with the torture claims or have the non-refoulement claims substantiated. Why won't they go home earlier? If they decide to be removed earlier, we can give them a bigger allowance. The later they decide to be removed, I think we can offer an ex gratia allowance. Whether or not you made a wrong decision or a right decision, you have suffered. You've stayed for so long in Hong Kong. You have to sleep under the flyovers and live in areas which are black spots for criminal activities. Originally, they hope to find better prospects in Hong Kong, but they end up with even a worse off predicament. So if they're willing to leave earlier, we can give them more allowance, more gratuity. If they stick to the bitter end, then I don't think they should get anything. I think these people would know how to do the sums. Now, if we adopt that approach, I think it will be more economical than spending billions of dollars on this. I don't think we should send out the wrong message. That is, if you go to Hong Kong, you will get an allowance or gratuity. So I think we should adopt a two-pronged approach. For people who come to Hong Kong now, they should be immediately, imprisoned. But for those people who've been here for so long already, would you consider would you be prepared to consider my suggestion? Well, thank you still for your suggestion. This is a new suggestion. At least in this committee, we've not explored that option. For all the relevant proposals, if they are effective and if they are legal, we are prepared to consider them. We are now proposing to amend the ordinance. After the amendment, of course, we hope that we can be more effective. We will be able to more effectively plug the loophole, the procedural loophole. But I understand that in other countries there are also similar arrangements. So perhaps at a later stage, if we could perfect our system to minimize abuse and people exploiting our loopholes, I'm sure that our system can, at a certain stage, consider adopting the proposal suggested by Mr. Ho. We are willing to consider them seriously. I'm very happy that the Bureau is willing to explore that option. In the last 4 years, you only have 2,300 applicants or claimants, most of whom have already been removed. 2/3 have been removed. The remaining 1/3 will be 8,000 people. If you give them $10,000, $80 million. $2,000 is $160 million, and so on. So for the next few years, we're already allocating more than $1 billion. So yeah, I think we can give them a gratuity and a flight home. If you offer that incentive, I'm sure many of them will be willing to go. Mr. Yu Si-wing, the administration just now in the presentation told us that the airline companies in other countries may not have seriously inspected their travel documents, and these people therefore are able to come to Hong Kong illegally, and the government is planning to increase the penalty. I'd like to know whether or not this is a very common phenomenon. Otherwise, what's the point of increasing the penalty on these airlines? And secondly, you say that you will step up communication with the airline companies and the other stakeholders so that we can have better immigration control. I think with India, you already have an advanced, declaration system. Could you give some examples as to whether or not this is really effective? And thirdly, for people who are awaiting repatriation and they're waiting for the ID documents and flights. Now, if the consulate office of their home country refuses to issue the relevant documents, what are you going to do? Will they continue to stay in Hong Kong, or will you forcibly repatriate them to another place? Regarding the airline companies, we already have such a requirement in the existing ordinance. That is, before passengers board a plane, they would be required to have valid travel documents. I think so long as the visitor does not arrive in Hong Kong with a valid travel or ID document, we already can impose a penalty. In the past, we have every year around 200 to 300 such cases. It is our understanding that the penalty has been set for some time already, so we might wish to consider whether, in the light of our present circumstances, we might need to change the penalty. And secondly, regarding liaising with the airline companies, I understand that the pre-registration system in India is successful. It's very successful. I think we're able to do two things. That is, the genuine Indian tourists can still come to Hong Kong conveniently. More than 90% of those people who apply for a visa online have been granted visas. Those who have not been granted visas, it is exactly these people who are most likely to come here to make a non-refoulement claim. After we've implemented the system in India, people from India, the number of people who overstayed or are applying for non-refoulement claim has gone down. Because of this successful experience, we have been inspired to consider whether we can, do even better. We understand that IATA, we're trying to find out whether IATA has new proposals regarding liaison between immigration authorities and the airlines and so on, and whether they have any any proposals that we can make reference of. I think, and whether we can also apply the Indian experience in other countries as well. So this is a review at the moment, and we need to review every aspect of the problem. And thirdly, the availability of flights to return these claimants. It has always been our practice that we need the cooperation of the home country before we can repatriate the claimants concerned. The major source from which these people come from, I think the most successful example would be Vietnam. In the past, the source country, the largest source country is Vietnam, meaning the number of people coming to make such claims. We have stepped up cooperation with the Vietnamese consulate office, and the number of people repatriated has actually, increased in multiple numbers. Chairman, he has not answered my question. That is, if the home country of these claimants refuse to confirm the identity of these people, how are you going to deal with that? And do we have many such cases? Chairman, according to my understanding, for a country to refuse to confirm the identity of such people is very rare. Normally, sometimes, the discussion may take a long time, and we're exploring how we can help those countries to expedite the process. And we also inform them as early as possible regarding those people whose identity will need to be confirmed. But as for you asked whether there are any countries which refuse to issue ID documents, we do not so far have such cases. These are only isolated incidents. Fernando Zhao.
主席，
I'm very concerned about the Security Bureau's proposal to tighten the Immigration Ordinance and the relevant provisions so that they would make the screening process more unfair, and also to lengthen the detention of the claimants. And then for the immigration detention center, to let the immigration officers to possess firearms and with anti-riot equipment. And currently the Correction Service Department don't need to carry their guns around. So why do we need to get to this? And for the views raised last time, whether the Bar Association, the Law Society, and other civil groups have raised a lot of concern and objections, especially according to your information, that the number of claims had drastically reduced and under control by 80%. So when you have greatly expedited the processing speed and the number of cases dropping dramatically, why are you undertaking this kind of rather exaggerated changes? And for example, on the submission of evidence and claim form, and you claim usually about 49 days and propose to tighten it to 14 days. Well, would the claimants not able to gather enough evidence? And for the language for the screening interviews, and you claim that don't need to conduct in their mother tongue, as the immigration officers and can determine that and able to reasonably supposed to be able to communicate in another language. I found it rather baffling that when people are escaping prosecution, that they left in a hurry, and they were told they were not able to or featured your languages, but even if you're not too proficient or only knew a little, so then I can conduct a screening interview not in your proficient language, and the screening outcome will meet the high standard of fairness. I doubt whether this kind of practices does not comply with the requirement laid down by the courts, and for the immigration officers to possess firearms and ammunitions. This kind of detention that do not require the use of anti-riot equipment and firearms. So, does that reflect that there's a problem with this layout of the detention center? I found the Dr. Jesus Ho's attitude unacceptable. So for the people who are escaping some threat, they may not choose to Hong Kong. So they might already be at a loss, and they claim that let's provide economic incentive, then they will leave right away. That's very disrespectful. You can't assume that each claimant come to Hong Kong for economic reasons. We can't just paint them with such a broad brush to assume that all of them come here to get benefits. As a legislator, this is not the kind of attitude to discriminate this group as a whole. P.S. And thanks for Dr. Cheng's concern. And for the detention facilities proposals, our proposal is not to strengthen the immigration department equipment. And for the day-to-day operations of detention facilities, and those on the Chesapeake Bay Immigration Center, the staff was already equipped or suitably equipped. For example, pepper spray, or anti-riot powder bomb to cope with any daily situations. And a few months ago, the subcommittee had done a duty visit to the CIC. So in this setting, it had happened, for example, the altercations between the detainees, and to protect the physical safety of immigration officers and the detainees, that the officers should be suitably equipped. And now our amendment proposals is more like a technical ones, because some of the government departments have been allowed to possess certain firearms. So the immigration department is not one of those. And so the personnel stationed at CIC may apply to the commissioner to police for exemption one by one on a personal basis. And in terms of there's a training bottleneck in the training. So to like to strengthen the internal training and deployment flexibility, and that the capability in emergency response handling have been restricted. To enhance their preparation, we suggested that proposing a corresponding amendment to include the immigration department. And on the language issue, it's not that the immigration department will not arrange interpreters. And to handle the screening, we already have over 20 in-house translators and interpreters. And we also engage non-government part-time interpreters from a pool of over 280 interpreters registered with the judiciary. In the past, the immigration department has been able to communicate with the claimant in certain language, and during the process, they claimed that they switch to another language or a tribal dialect. So, taking reference of the handling in other jurisdictions, I've decided they are of value to us, including the German legislation have such similar requirements, and now we have adopted a similar arrangement. And for the time frame to submit the claim form and the submission evidence, so we debate on whether it's 49 days or 14 days. Even if we have 49 days as a usual time frame, if the claimants require more time, they can apply for the immigration if they have justifiable grounds. Of course, we agree that for the genuine claimants with genuine need will willing to offer extension, regardless of the complexity of the cases. Or should we give them just 49 days, or should we start with 14 days and allow them to extend for other circumstances? We take reference with arrangements, for example, Canada. In Canada, is 15 days. So we're adopting a similar standard. Next, Mr. Dennis Kwok. I'm myself very amazed that the legislator have proposed to offer money to entice the claimants to leave. That's a very sensational and impractical proposal. So that's the first time I heard in this discussion. A question for a PAS. So you showing the claim situation. There are about 1,300 cases pending processing. Do you have any figures I've overlooked? I remember over a year, there are about 10,000 cases. That is end of October snapshot. So you see the dramatic improvement then. I don't have the old records with me, but those pending screening at its peak was at 2016 upper half. Back then, there were over 11,000 cases. And the Immigration Department in 2015 and 16 have been trying to expedite the screening. So they take on two directions. So first will be the capacity, as well as the time would take, whether they can be shortened. Besides the immigration adding more manpower to screen cases, we also boost the number of translated interpreters available. That another bottleneck with it in 2017, and we have launched a pilot scheme for legal assistance. That we are engaging another referral service, boosting number of cases from 13 daily to 23. So they allow the Immigration Department to deal with 4,000 to 5,000 cases annually. So that's the development. So besides boosting the manpower, you also with better interception. I think that this all within our scope of control. They gave rise to another problem. Dr. Chang also mentioned that if things are already moving so quickly, would be able to meet the very high standard of fairness set by the court. And second, other countries like in UK, there's a appeal court proceeded, and since the time frame is so compressed that it was overturned on judicial review. Well, you have tried once before and you lost the case. And those screened cases, we have to start over. And for the over 10,000 cases, most of them were due to government botched up handling and lost the case, which bring this huge backlog onto the gap itself. And you see there's a dramatic improvement in the numbers. And you are compressing the time frame whether it would meet the high standard of fairness. And from foreign experience and proceedings, are you worried about the risk of judicial review? 3 questions. Thank you for Mr. Kwok's comments and question. Let me clarify first. So objectively speaking, that the government lost the case in judicial review. Over 20,000 cases under USM. About 16,000 of those were raised after USM, and they are new claims, which made up 80% of the total number of claims. Therefore, we don't accept the narrative that just because we lost the judicial review and just led to a huge backlog. That's simply not fact. As for whether our handling procedures and for our current proposals, that we make sure that able to meet the high standard of fairness set by courts.
If the procedure we come up with does not satisfy that standard, it would actually not be in compliance with the law. All the measures that we will implement will have to be legal and enforceable. Regarding the system in the UK, I think the period for appeal was reduced to 2 days, and the person concerned would need to lodge an appeal within 2 days, which compared with our present proposal, it's much shorter. Of course, we will pay attention to the experience in other countries. But it's all right. Now it's my turn. I think the situation is now improved and the backlog has gone down from 11,000 during its peak to now 1,320, and this is a number for October, and I think that number should be even smaller now. So this shows that over the past period, we have been urging the government to expedite the procedure. We've also, provided more resources and manpower to actually plug the loophole at source. Looking at the present figures, we have 22,000 applicants and 8,000 have already been removed. We have about 8,000 appeals. And 6,000 who needs to be removed, but they have yet to be repatriated. And you also have 16,000 people in custody, and some others, applying for JR. You have 6,000 people who need to be removed as soon as possible, not counting the 2,800 cases where the JR is pending. What is the reason why they're still not yet removed? You say you're now arranging for 1,600 people to be removed, and they're applying for, the necessary documents the re-entry documents. Besides that, you still have several thousand people who have not yet applied for flights and also re-entry documents. Why is that? Thank you. Of those 6,000 people, as I said, 1,600 are in prison, or there are some criminal proceedings, pending. Of course, they are not yet released from prison, or if the procedure is not completed, we will not be able to repatriate these people. Sometimes, when we confirm the status of these claimants with certain countries and ask for the relevant documents, well, I think there is an expiry period for these documents. If we were to do it earlier, and such documents might have already expired its validity before we can repatriate these people. So are you saying that you have to go through all the JR procedure before you can arrange for such re-entry documents to be made? So in other words, you cannot apply for these re-entry documents beforehand. Well, at the moment, what we do is that we would wait first. If the relevant, host country, I think, is willing, and we're actually discussing with them as to whether or not they can allow for a longer validity period for the re-entry documents. That would give us more leeway. Of the 2,800 JR cases, it has always been our practice and policy that the person to be repatriated, once he has applied for JR, we would suspend the repatriation process. That has been a long-standing practice. It's not a special arrangement for the non-refoulement claimants. Of those 6,000 people, the number of people for whom removal can be implemented is 1,600. Now, on average, how long would it take for these people to be repatriated? And what is the longest time it takes to repatriate? It would depend on which country they come from, and it's not entirely under the control of the SAR government. For some countries and the governments, we've been talking to them a couple of years ago. We were looking at the numbers, and I think they have been responding very quickly. If they are very cooperative, then I think we can have a more expedient arrangement. The shortest will be a couple of weeks to a month for us to complete the procedure. For other countries, it might take longer. They might require us to furnish more information. So all the back and forth may take 3 to 6 months or even longer. So we have already, so what is the biggest problem that you now face? Is there any solution for that? Because you have to wait for 3 to 6 months or even longer. Meanwhile, where are these 1,600 people? Well, most of them are still, in Hong Kong with permits to stay to stay, but we're worried that if they are continue to be kept under custody, it will be against the common law. And also, the only large facility we have is in Castle Peak, which has a limited capacity. So if we have to wait, unless we have the documents ready and that they are soon to be repatriated, otherwise we would give them reconnaissance papers. Jonas Ho, second round. Chairman, the allowance that you give each of these claimants every month, how much is that? I think it's roughly about $3,000 to $4,000. $3,000 to $4,000. You have 22,000 cases, 8,000 have already gone. You have 8,000 applying for appeal. There are 8,000 who need to be removed as soon as possible. You still pay them the gratuity. Yes, if they're necessary, we will continue to pay the allowance. So they pay each $3,000 to $4,000. That is inclusive of meals and daily allowance and everything. How many of them are living under flyovers? The South Indian village. I'm sure you have the figures. The humanitarian support we provide does not mean that we give them this standard, support. Right now, the SWD will refer them to the relevant organizations, and those organizations who have social workers to assess their needs. So I mean, even though the funding comes from different sources, it's still, the bill is still, foot by the taxpayers. Now, for these unfortunate people, if they only have an allowance of several $1,000s, if they can't pay the rent, they will be living on the street. So has the SWD or the Security Bureau conducted a survey to find out how many of these people are now, street sleepers? We don't have such numbers. All the refoulement claimants. No, I don't. I think you need to follow up with the SWD. That is, if you pay them $4,000, is that enough for them to make ends meet? And how many of them are sleeping under flyovers? I think we have to know. My question is as simple as that. Some people, is being generous at other people's expense. I think if you check the numbers, you would know who are the genuine claimants. Of course, many of them are, fake, claimants. Otherwise, you may as well invite them to live in your homes. We have 14,000 people who are paid $3,000 to $4,000 a month. So we're already paying them that much. It's simple arithmetic. For these appellants, we're not saying that we should deny them the chance for appeal. I just want them to give an opportunity so they don't have to sleep on the street. If they're paid $3,000 to $4,000 a month, why don't we pay them a little bit more so that they can leave earlier? That is an incentive. Why are you saying that this is inhuman? If you cannot even make that analysis, how you're not eligible, qualified to be a council member? Fernando John, do you know how much money we've spent in the last 5 years? How much the government has spent? I'm sure you don't know because you don't pay for it. I think the administrative expenses already amounts to $1.4 billion, legal expenses $700 million, living allowances $2.7 billion, totaling $4.8 billion in 5 years. For these 12,000 people, 14,000 people, if we let them leave earlier, I think there's no point for them to simply procrastinate. So give them $10,000. It's still $140 million only. 14,000 people. Give them $10,000, $140 million, and double that if you pay them, $20,000. Last month, the security panel, apply for the creation of 2 supernumerary posts and convert them into a permanent post to deal with the question of non-refoulement. And you also criticize the Bureau saying that this is wrong. You don't have a solution, then the ministry is now proposing a solution you say is not human. So what are you saying? Thank you. Madam Secretary, any response? I can only reiterate that we are willing to explore all, feasible and legal options. Chairman, I'd just like to make one demand. How many of these, claimants are now street sleepers? Give us the number at the next meeting. Well, we don't have the numbers in hand because each applicant or claimant, we would refer them to the SWD and the International Agency for assistance. Whether or not they need the assistance is the decision of the claimant. If they have the need, we will provide the necessary gratuity or allowance for them. As for accommodation and the rental allowance, the agency will directly pay the landlord instead of paying cash for the claimant to pay the rent. Of course, we can tell you how many people in Hong Kong are receiving such support. But for the number of people who are not receiving such support, it doesn't mean that they are street sleepers. They could be. I certainly understand. That's why we need to follow up. We want to know what is the situation of these claimants. That is, how many of them are street sleepers, how much allowance they are getting. We should have the statistics so that we can know what the whole picture is like. I think you can communicate with the SWD. Fernando Zhang. Thank you. Mr. Jonas Ho, I agree that you should ask that question. That is, whether or not there are people who are street sleepers and how many there are. Mr. Ho, you may not know that these claimants, the rental allowance is $1,500 per head. It is the International Service Agency which directly, reaches an agreement with the landlord. It's 1,500 person per head. Mr. Ho, could you help me find out whether one could rent a unit for $1,500? For meals, $1,200. It's not cash either. It's actually a supermarket coupon, and the claimant can use it to procure food at supermarkets, and they can buy food at 2 supermarkets. So for these refugees and the non-refoulement claimants, we don't give them cash, support. Mr. Ho was talking about money. I didn't look at it from the monetary angle. I'm looking at it from the humanitarian angle. For people who are running away from torture or they've come to Hong Kong. And from time to time, I will visit these asylum seekers. I've seen the environment in which they live and the predicament, which is indeed very difficult. I've heard also many of the stories. I also know how they, escape from the country and the repression and the threat to the personal safety in the home country. I hope our colleagues and this committee can also visit them. This is better than simply looking at this in the abstract and discuss how we should deal with it. Since, Mr. Ho, you agree that we should be more practical, I would like to boldly suggest that I can make the arrangement with these organizations so that you can meet with these so-called fake refugees and see how fake they are. I don't think we should use such an adjective to describe any person. for these people, many of them have been some of them have been in Hong Kong for a long time. Some have been here for more than 10 years. Some already have children. For children who are under the age of 12, their allowance is cut by half. It's 750 for rent and 600 for food.
So I wonder that with Hong Kong standard of living, how could you live on that money? I hope that we can arrange that. So if we had visited the immigration detention center, why don't we cooperate, have the NGOs arrange visits to the asylum seekers and visit them, so that our members can talk to them, so that we can have a face-to-face dialogue. So if you have questions like why you coming to Hong Kong, so what kind of prosecution you're under, why you're not willing to leave Hong Kong, I'm making such requests. Dr. Chang, I visited these NGOs to visit the claimants. Like I said in the subcommittee, I'm not saying that all these claimants are bogus refugees, and can't say that all of them are genuine refugees here. So I'll probably have both real and bogus refugees. Some of them do need assistance. We hope that we can assist them more based on humanitarian grounds. And on the other hand, we're seeing a lot of us abusing our current mechanism. So the task of this subcommittee, let me reiterate, that how to use all possible ways on a multi-channel approach to address the issue of abuse, so we can have the right condition to treat those with genuine need better. And so what you said here is assuming that all the non-refoulement claimants are genuine refugees. Thus, for us to visit them, they would get to know the truth. So I won't rule out that some of them are in a predicament, and some of the families are substantiated as genuine refugees, and they are awaiting resettlement in third countries, in this case Australia. So I did talk to them to know of the difficulties of their time in Hong Kong. That doesn't mean that we don't need to address the issue of abuse. I think we should be focused on the abuse issue so as not to make Hong Kong paying such a huge cost for the economic wise and in law and order. One of the terms of reference of the subcommittee is talk about these humanitarian treatment. That will be discussed at the next meeting. Of course, we had to combat abuse, and we also have a lot of claimants with genuine needs. So I have made such suggestions. So let's see how the chairman would handle it. We'll see other members are interested. It's best to have a face-to-face dialogue. Well, some of the cases managed by the NGO believe that they have performed a screen themselves, that have probably required at bona fide cases and awaiting government screening. And however, they're probably not the entire picture. So I can canvass the other members' interest on this. Well, we can meet those pending screening. Well, since you claim 90% are fake refugees, so let's meet those refugees, about 90% who may be fake. About para 6. So we asked about the number of leave for JRs at about 2,500 cases pending JR. I would like to know the total number of claims lodging JR and their results. And what is the government expenditure on that? And however, this figure is not provided. I hope that you can provide us this figure just to let us have a grasp of the situation. And for paragraph 1516, we'll talk about the management of detention facilities, and Dr. Chang asked why that we need firearms are needed in detention facilities. To amend the Firearms and Ammunition Ordinance is my proposal the past 2 years, and to be reflected by the Immigration Department staff that waited for deployment and training on dealing with emergencies. They came across some difficulties. With more of these non-refoulement claims have been put into detention, they came across problems in the day-to-day management. For them to apply for exemption, they need to do it on a case-by-case basis with the police commissioner for the use of firearms, and need to train their staff on using anti-riot equipment and refresher courses. The law currently does not provide for that. They will need to seek the help of CSD. The CSD already experienced severe shortage, and asking them to help with the immigration training is very unsatisfactory. They will bring a lot of pressure on both departments. For the past 2 years, I've been lobbying to the amend the law so that they can able to more flexibility for the internal training and for deployment flexibility, and also enhance the capability to emergency response. So that's the background, and now the government has finally responded to the aspirations of the immigration department staff. Dr. Chung, you mentioned that why such equipment is required. And if you have a sympathy for those non-refoulement claimants, I hope that you can often extend this sympathy to the immigration department staff. They are in a very difficult work environment. These claimants are not all nice people. Some of them are broke the law multiple times, being incarcerated and returned to the detention center. And since they were so even if they broke the law or make a scene at the immigration center, since the CSC can do nothing about it, since they are neither a correction institution or prison cell, and if the immigration center is full, there will still be issued reconnaissance papers. So their management is very difficult. I hope that the immigration staff would able to control any emergency or risky situations so that the other detainees can be protected, and also protect the safety of the immigration staff. So I welcome the government had finally responded to my suggestions and listened to the immigration staff. That I would like to supplement on the other members' question. PAS, any supplement? Thanks for the chairman's suggestion. On judicial review, we'll invite judiciary to provide the figure on expenses. The paper mentioned that for 2015 to 2017, the number of applications for leave for JR for the first 10 months of 2018, the number of applications for leave for JR to over 2,000 cases. However, this is not an accurate figure we have, so just want to have a caveat here. And about the 1,100 cases and the 2,000 cases for JR this year, the court, for instance, have processed 9,000, close to 1,000 cases. About less than 2% have been granted leave to JR. That's the latest figure we have on hand. And for other questions raised by Chairman, we'll continue to follow with the judiciary. Third round, Dr. Julius Ho. Thank you, Chairman. Let me make it clear that this life currently by this group of people is not miserable. Even with the food coupons, they only give you vouchers. They're only $54,000 a month. So they're living below the poverty line. Currently, the poverty line is at 38,000 or 3,900,000. 3,800 or 3,900,000 a month. So your level allows it pretty much close to poverty line. So I'm not claiming they're not miserable. Well, the figures and the figures provided to you show that how's the successful percentage. Even if the claims were substantiated, or they're able to be qualified under the USM, the percentage is minute. And we can see from the actual numbers, so there are a lot of people still in the process. If you do provide them a way out, they're still receiving $3,000 to $4,000 a month. Why not offering a generous stipends rather than living here miserably? So instead of offering a solution and instead engaging in tug of war, is very painful for both sides. So I'm not talking about removing them before screening. We have a very comprehensive mechanism. So for 5 years, the legal costs are over $700 million. They enjoy legal representation, and they have been through the due process and with a McKeel mechanism. And now the figures have told us that over 6,000 of those are awaiting removal, 8,000 in the process of appeal. So how do we break this dilemma? So we need to have a conscience instead of just claiming don't touch them. That is actually very inhumane to them. So you claim it's humane, but you're not offering them a solution. Why not just offering $10,000 or more to see if they're willing to leave? That's an option that can be exercised by them, or maybe we can do the math, or rather than suffering. Oh, there's probably a big house waiting for me in my homeland, and for here I'm in a shoebox or not, or even under a flyover. Well, if their home is worse than in Hong Kong, than worse than their homeland. So do we have such kind of people that you just where we can all the option to take the money? It's not that I'm just paying a ransom. It just we shouldn't just let this continue. I'm offering a choice, and you equate this choice with inhumane. This is irrational and unanalytical, and you have no idea of the scale of spending at present. You're spending taxpayers' money. That's why I'm asking. We're spending is $4.8 billion in 5 years, and for HCMB Bridge, well, you're maybe screaming. We're talking about hundreds of billions. And for those who don't need to be here, well, they can leave voluntarily. So I can able to offer ex gratia payment to leave. When it's not compulsory, it's pure, that would be purely voluntary. Why not offer this option? So Dr. Chang, why not? So that's why when I mentioned PAS, shouldn't be considered. Well, this is not my idea. I read that from the newspaper. That actually could be given a small amount of allowance when they bought the plane. So just want to extrapolate from there that what are we talking? We talk about non-refoulement claims USM. We're thinking from the humane perspective so that they can reduce the misery. Well, everyone knows they're miserable. I don't need to sleep on the street myself. So that's a common wish, is to make them stay away from the streets. Whether they have enough to live on is another question. Well, if those who have a genuine need to stay in Hong Kong or to other countries, if the amount not enough, that we need to raise the level. So don't miss my point.
Any response from you, Permanent Secretary? Yes, I've heard Mr. Ho. Fernando Joe. Thank you. I think Mr. Jonas Hose has a point, although, well, in my first response, I think his attitude is rather disrespectful. That is, you say to the claimants that we pay you the money and then you can leave. Well, this is a bit like an academic discussion. I think Mr. Ho's suggestion has, highlighted the crucial issue here regarding our policy on non-refoulement claims. Whether we have screened these claimants and confirmed that they have been subject to torture and shouldn't be repatriated, or that their application is not substantiated, the claim is not substantiated, and there's no reason why they shouldn't be removed. For either case, we don't plan to let them stay in Hong Kong for the long term. If we confirm their status, we can give you a reconnaissance paper. If we don't confirm their status, we give them a reconnaissance paper and stay in Hong Kong temporarily until we remove them from Hong Kong. It's not possible that they will eventually stay in Hong Kong permanently. So imagine whether there would be people who would deliberately come to Hong Kong just to collect the $1,500 rental allowance and $1,200 food allowance, which is not in cash, and to suffer like that. And in the end, they still cannot stay in Hong Kong. If these people have come to Hong Kong for economic benefits, then I think the Security Bureau and the Immigration Department had already repatriated a large number of such people. We still have, a batch of such people remaining, but are these people the so-called fake refugees, like some members suggested? And I think our substantiation rate is such that if you look at the report by the Secretariat, you'll know that internationally the substantiation rate is at least 20, 30, or 40-something% rather than 1% or less than 1%, Mr. Ho. You have to understand that this rate, that is the percentage of such claims being substantiated is extremely low. When NGOs and legal practitioners and the way we handle these refugees in Hong Kong, if we show this to the UN and international organizations, they would all say that there's something wrong with what we do. Why is it that the confirmation rate is so low? Even the UNHCR in Hong Kong talked about the success rate of more than 20%. It is only the ASEAN government which has such a low percentage. So I think the pictures will now gradually getting clear. If you think that if you give these people an economic benefit, give them $10,000, $20,000, I'm sure they immediately leave. What reasons are there for them to stay on? But if you look at it from a different angle, if they really are refugees, you pay them $10,000, $20,000, it doesn't mean anything, because when they return, they will be subject to torture and danger. They want to stay to find a way to go to a third country. And that's why I suggest that we should have a direct dialogue with these claimants so that we can understand, we can hear from them directly what had been the experience and the problems that they are now facing. You can ask them, let's say, if you give them $10,000, $20,000, $100,000, are you willing to leave? I think you would get a clearer picture if we did that. And that is much better than, you know, you know, expressing opinions based on our different experience. I think we should really talk directly to these asylum seekers and let them tell us what exactly is the situation. Dr. Fernando Zhang proposed that we should meet with the non-refoulement claimants. I think we can certainly consult with the other committee members. Mr. Zhang said that if we meet with them, we'll know the truth. I am rather skeptical. Just because we meet them, just because you have reports in the media that some of these claimants, actually belong to criminal syndicates, and when these refugees come to Hong Kong, they have to pay for the passage, and so when they come to Hong Kong, they will take part in, they will join criminal syndicates. Of course, I'm not talking about all these, claimants, but some are actually illegal elements coming to Hong Kong to break the law. In fact, we have seen instances of burglary, smuggling, and so on, and some of these people are being arrested. For people who really are subject to, torture, they will not leave. For these cases, like Mr. Ho said, for those people who pay a certain amount of money for the passage to come to Hong Kong to take part in criminal activities, again, I don't think they will leave. For those who've come to Hong Kong and apply for non-refoulement and we pay them for them to leave, I'm worried that if we send out such a message, there would be others who would deliberately come to Hong Kong for that reason. Well, that is something that we can also discuss, but we may need to think about that. Now, in the PowerPoint presentation on page 11, regarding duration of detention, the government suggests that we should make reference of the legislation and case law concerning Vietnamese refugees in the 1980s and prescribe that other than the screening and the progress of repatriation, we should consider other factors. I'd like to know what are these other considerations, because many people in Hong Kong are most worried about law and order and personal safety. And many people have told us that for those claimants who have committed serious crime and after they have released from prison, we should not give them reconnaissance paper again, or also for repeat offenders again, we should not give them reconnaissance papers to the public. You say you will consider other factors. Will you also take those factors as well into consideration? If you look at the practice with Vietnamese refugees, though the factors, at that time there was a large number of these people who came within a short time. And at the time, the administration was not able to process such a large number of refugees or boat people who came. So in the law at the time, we had the provision. That is, we have many cases pending and we didn't have enough resources to screen them. And if we continue to keep these people in custody, it would not be unreasonable. So that was the approach then. Of course, we will make reference of that experience. As for the other considerations like law and order, we certainly go back and explore this. But that's not the experience we had in dealing with the Vietnamese refugees. Well, we don't know too much about the case, the situation in respect of the Vietnamese refugees. So under what factor conditions would you extend or shorten the detention? I think the provisions in the law, that is, in considering whether the detention is reasonable, we will take into account, for example, how many people are waiting for screening and repatriation, and whether the persons concerned are not cooperative and stalling the procedure. In such scenarios, the Immigration Department can continue to keep these people under custody, and it will not be deemed to be unreasonable. We are considering whether we can learn from that experience. We certainly also look into the proposal made by the chair. Jonas Ho. Question for the Permanent Secretary. For those non-refoulement claims which have been substantiated, there are not many. There are only 77 according to your figures. So what is the latest situation? How many countries have agreed to accept them? Thank you. For the cases confirmed by the Immigration Department, there are 77. There are 44 cases which have been substantiated after appeal. That is, the appeal board overturned the Immigration Department. So you have 121 in total. For all these cases, we will refer them to the UNHCR and make arrangements for them to be repatriated to the third country. So far, we have referred the cases that we've referred to the UNHCR. 4 have been repatriated to a third country. I also like to mention in passing that under the current legislation, for all substantiated cases, if the claimant thinks that it is necessary, they can apply to the Immigration Department for the right to work here. But this is only applicable to substantiated cases. That is, only 4 cases under the UAM have been implemented. There had only been 4 cases. After the implementation of the UMS, there have been 121 confirmed substantiated cases which have been referred to the UNHCR, and they accepted 4 cases. That's less than 2.4%. For the remaining 117 cases, they can apply for a permit to work in Hong Kong. Counting from that moment, if they stay in Hong Kong for 7 years, would they be eligible to become Hong Kong residents? No. The answer is no. Non-refoulement claimants either have come to Hong Kong through smuggling or have overstayed, or some of them have been rejected entry when they come into Hong Kong. Before we had UMS, whether it's refugees could get ID papers in Hong Kong and stay. How many of them ended up staying in Hong Kong? I think that previously many Vietnamese refugees, who didn't go to third countries, actually stay in Hong Kong. Thank you for the question. For the Vietnamese boat people and refugees, the way we handle the problem is different from what we are dealing with how we're dealing with the non-refoulement claims now. At that time, we have special arrangements in respect of the boat people from Vietnam, and indeed, some of these boat people have stayed in Hong Kong permanently. But for the non-refoulement claimants, there had never been any such claimants just because they made a claim in Hong Kong or stay here for a long time that they have been able to allow to stay permanently. So my third question, you are 121 cases which have been substantiated in the last 5 to 7 years. How many of these substantiated cases these people are still living in Hong Kong and giving work permit, other than not being granted the right of residence or status or passport? Before we had the UAM, under the torture claims, we don't have the numbers. Do you have a ballpark figure? Several dozen, not many. For those who apply for work permit, I think they would also be among those who are not more than 40 in total. for these 120 odd people, for these cases which have been referred to the UNHCR, we hope that their repatriation could be arranged as soon as possible. That's what you hope for, but that's talking in the abstract. You hope that they could be removed ASAP. Do we have a target? Can we tell what would you tell the UNHCR if they don't, help repatriate these people? Because you won't, tow them out to the open sea.
咁
A non-refoulement claim substantiated will not remove them. As for the UN, the Immigration Department will regularly review the claims progress. So it can't rule out that if there are any changes to the claiming circumstance at that of the country, and such risk disappeared. Well, that's voluntary. Well, we're also that we are stuck with these people. Well, they will consider these claims can leave at their own accord if there are any change in circumstances, and if the risk of the claimants have disappeared, then we will invalidate its substantiated status and arrange removal. And for the 120 cases that we don't have any of those. Hope that the Bureau can provide us more figures. Out of this 120 odd people, so -4, 117. So what will their future status be? So what are the options available? So we just talked about ballpark figures. So we can discuss it at the next meeting. Fourth round, Dr. Chung. I'd like to follow up on Dr. Ho's question. I think Dr. Ho raised a very good question. Just to give it a better idea. So that means they can't stay in Hong Kong in any case under this mechanism. Well, for Vietnam, yes. For after the closure of Pak Shek camp, I think about 2,000 odd refugees granted permanent residency or Whitehead Detention Center. And for the 117 substantiated claims, so how many of those managed to obtain an employment visa and now working? PAS? They need to apply the employment visa on the initiative. We approved 39 of those. And about 10 of them, the application denied. There are about 39 individuals have the application approved. 10 of them denied or not able to take further action because they failed to show the evidence of an offer. The application is contingent upon an employment offer. But shouldn't that be improved? So after they survive so many procedures and survive this low substantiated percentage, which is less than 1%. So these are, I suppose, these are very genuine refugee claimants. Since as we established that we should not repatriate them, and for a long time they're not able to work, and after the claim substantiated, at least we should bring some meaning to life or even contribute. And yet our rules require them for them to obtain a job offer from the employer first, and then have to wait for the employment visa before reporting to work. As you can imagine, that not a lot of employers will hire these people who've been suspected as criminals and not of this, doesn't speak the same language and doesn't belong to the same race. So they shouldn't be relaxing the requirements. So they just grant them an employment visa for them so that they can get a job. And when their finances circumstances improve, then they will stop. They need to be on our allowances. I heard that a lot of the asylum seekers, they would like to reciprocate. Shouldn't we take a relaxed approach for substantiated cases? Shouldn't we allow them to work in Hong Kong? When it's come to employment, we've been handling very delicately. In the past, there have been court ruling, and have been ascertained that they have no right to work in Hong Kong, and this employment arrangements are rather special circumstances. Since their cases are substantiated, we have no idea how long they will stay here. So taking into account that we have the need in making the application, and for the number of cases mentioned by Mr. So, LD 40 to 50 cases, well, these are the cases approved. So I see the huge percentage of those able to meet that requirement. Where there are some other cases that warrant further handling or review, that will look back to. So if we claim 117 cases, 39 successful cases is not a big percentage. And a lot of the employers are NGO themselves, which could take care of this asylum seekers because they know best of the problems, and they were also willing to show the immigration that they have a employment offer to make the application successful. So we don't have that many NGOs having this lot of resources and hiring this substantiated cases. So I know that they don't have the right to work in Hong Kong. So regardless of the time here, they're not able to apply for PR with that status. So before they leave Hong Kong, so as after they've been substantiated, so for the meantime, they allow them to work. There will be a win-win situation. That should be encouraged instead of restricting them. I think you should waive the requirement for the employment offer requirement in the employment visa. If you deem them as fit for work, they should grant the visa so they can look for work. Or you can require them to report to immigration from time to time so that the immigration can know of the employment situation. And the reporting requirement has never been waived anyway. So do they have any security grounds to restrict their right to work? P.S. Would you consider any legal issues? So it had to do with two provisions. So and now it's stated that the substantiated cases have been written in law that we're able to apply with a visa. And for the other considerations, I need to discuss with immigration. So it's my turn, fourth round. So the biggest backlog will be the number of cases pending TCAB. There are 6,484 cases. Well, this figure have stayed for quite a few months. So what are your future plans and how long do you estimate to clear this backlog? So any way to expedite it, the clearance. So we are trying our best. The chairman, actually, you notice that the number have been kept this way for a few months. And for just over 1,000 cases by immigration, we'll complete the screening. And for the next phase, after mid-year, the number of nil appeal cases will be drastically reduced. And For the past 2 years, we greatly boost the number of board members to TCAB. Our target is that we're able to handle 4,000 cases a year. When we add up the two, we hope that we can clear the appeal backlog within 2 years. So you claim that you only handle 4,000 appeal cases each year. Any way to make it even quicker? Well, in total, TCAB members have been doubled from 20 to 100 actually. And we identified as suitable individuals. The membership can be expanded, and the work of the TCAB requires experience and professional expertise. And if there's mishandling at TCAB, would give rise to other problems. In terms of identifying suitable candidates, we have to be prudent. In the past 2 years, besides relying on retiring judges and magistrates as TCAB members, we also scout candidates with similar experience abroad. And we have also boosted supporting facilities, for example, the establishment and the secretariat, and the number of interpreters as at the venue for hearings. So the handling capacity have started from the low base to reach the current 4,000. So we've explored for the option how to boost the capacity further. So we have 6,000 cases and about over 13,000 cases, and so in total there will be over 7,000 cases. And to clear them with 2 years, how much are you asking for the taxpayers with all the administrative expenses, humanitarian support? So how much more must we spend? Take this financial year, for example. The annual expenditure or estimate is about $1.4 billion. And for the project expenditure for the next 2 years, I don't have them at the moment. So in terms of removal, I expect to be ongoing. And for we'll have a drop in number of new claims. We hope that the number will fall, but we don't have such estimate ahead. Well, you haven't handled this number of appeals before, so we take it step by step. So the expenditure incurred in the past 2 years mainly on spent on screening by immigration as well as interpretation and legal assistance. And next, we'll need to ensure that they have enough support at the appeal stage. And for the completed cases, we arrange for their removal. If you do the math just for dealing with appeals, the humanitarian support, we talk about quite a few $100 million. For 6,000, and well, that will be $300 million a year, and the next 2 years they will soon go up, and excluding the expenditure for legal assistance. And on average, how much do we spend on each case on legal assistance? Under the current arrangements, well, during the immigration screening stage, they are provided with legal support. For whether they will get legal assistance at the appeal stage, the lawyer will look at the case and will inform the claimant whether it's worthwhile to go to appeal. If it's not worthwhile, deemed not worthwhile, then we not cease to provide legal assistance. And the current figures and the number of cases which are deemed worthy of appeal is about below 10%.
咁就係
So for these 10% of cases which have merit for appeal, we will continue to offer legal support. Under the legal aid scheme, for such cases, they will still be funded by public funds. On average, if I remember correctly, each case will cost about 10,000. So 6,000 would mean 6 million, right? So that's the ballpark figure. Anyway, I think taxpayers' money will continue to have to be spent on this. We now have the fifth round. Mr. Jonas Ho, 3 minutes. I think the picture is becoming clearer as we, continue our discussion. But I think at the next meeting we may forget some of these numbers. The Permanent Secretary, we've already discussed several matters. Perhaps you can give us a table. I'm sure you can. I've also, jot down some of these numbers. For example, how much administrative expenses, legal expenses, and allowance granted in the last 5 years. The number was $4.8 million, according to my calculation. You have to handle 15,000, and now you're talking about 23,000. So the denominator and so on. I think at different period. Before the UMM, you have a number of claimants and others after UMM. So it's quite confusing. Please give us a table. So tell us for the last decade or so, how many cases have been processed. And the most crucial period will be last 5 years after we've introduced UAM, and tell us how much we've spent. Usually every year we spend more than, 1 billion. That would be more than what I thought. If we spend, 1 more million, it will be more than 50 billion, more than 5 billion. So please give us, an overall table. Also, there's some confusion regarding terminology. The appeals are administrative appeals under the Immigration Ordinance, and it's an appeal to the tribunal, and those cases are handled by duty lawyers. You have the screening, and during the appeal, the claimant will get legal representation. It's automatic. So for such appeals, from the preliminary screening, after the case is rejected, you have an appeal. How much does it cost, the whole process? And after the appeal is lost, they would take the appeal to the court, or rather the JR. They apply for JR. You told us that only 2%. You told us that there are 2,000 cases by October this year. Between 2015 and 2017, you have 1,100. You have 3,000 JR applications. That's after they've gone to the tribunal. You have 3,000, applications JR, and 2% would be substantiated. I think 20 out of 1,000 cases, yes. So I think you need to grant leave first before you have JR, right? If leave is not granted, of course, it will not progress further. I think that is a very important figure. Administrative appeal after the tribunal. I understand you have about 3,000 applications for the JR. That is about 3,000 out of 23,000. Go for JR after going through the administrative procedure. I thought you were talking about application for leave, because leave is mandatory. I thought it was 2%. You said you've processed 2%. I don't quite understand. From 2015 to October this year, according to our information, the total number of applications for leave for JR is more than 3,000. According to information available to us, the court has already handled 1,000 such applications. Of these 1,000, about 20 have been granted leave. The other 900 odd applications have been rejected. the CFI did not grant the leave. So there are 2,000 more pending. Well, this is again very alarming. Madam Chair, you asked a question as to whether the judiciary will have the manpower to handle these cases which have been stuck with us for so long. Justice delayed is justice denied. I'm also concerned about this. Yes. So is there any solution that we can come up with to fix this? So please give us such information at the next meeting. Fernando Jiang, your fifth round. We will, adjourn at 6:25. I wonder whether we have a detention policy when in the whole application procedure, at which stages would they be likely to be, detained? What will be the ground for detention? And how do you determine the duration of detention? Could you give us a paper or a table to enlighten us? And also explain to us what is the overall policy regarding detention. I'll briefly respond and we'll provide the details at the next meeting. On detention, so far the Immigration Department will look at each case on its own merit. We've already announced for some time our detention policy is also on the internet, and you can go to the police website and the Immigration Department's website. Well, we take into consideration different factors, including whether the claimant doesn't have a permanent residence, or if the case is about to be concluded and repatriation is imminent, in which case there will be a bigger chance of detention. But so far, we don't have a policy stipulating under what conditions a person must be detained. In the past, the court has given us directions suggesting that we should look at each case on its merit. Do you have a rough, duration? Normally, let's say you wouldn't detain a person for more than so many weeks. We don't have such a limit. As we explained, well, the duration period must be reasonable. That's what the law requires. That is, we have to look at each case on its merit. It doesn't say X number of days is reasonable and so on. It really depends on the circumstances of the case concerned. So that's very abstract. I understand I've read your detention policy. It's only a page or so, and it's rather vague or abstract. So regarding the entire non-refoulement claim procedure, I'd like to know at which juncture there's a possibility that these claimants will be detained. What are the factors that you will take into consideration to decide on detention, and what is the duration? And also at those stages, tell us what was the shorter and the longest period of detention, so that we get a better understanding of how you implement your detention policy. I'll go back and try my best to see whether I could provide the information. But a simple answer is that at any time the claimant, it's possible the claimant might be detained, so long as the Immigration Department thinks that there is such a need, based on the current policy. Of course, it would exercise that, authority carefully. I'll go back and, look up the relevant information. All right, if there are no further questions, our next meeting is scheduled for the 15th of January next year at 2:30. For outstanding item will be the legal aid system and humanitarian aid or support. Also, we hope there could be a follow-up to the matters that we have discussed today, especially the numbers, what is the latest numbers, how much we have spent, and what is the projection of the future. You may wish to ask the other departments for such information. And if we do not further extend the term of this subcommittee, that the next meeting could be our last. All right, if there's no further business, we're now adjourned. Thank you.